Hi, Kate Floss from the Ministry of Protestant Courts. As you all know, that I did recently we had a court hearing. We went to the court where I am petitioning using the 1688 Will and Mary, the Human Rights Act, Section 5, subsection 2, KII, that says that New Zealand will be bound to any international instrument on human rights laws. Now, this is a very dangerous law because it can mean they could make any law in the future and New Zealand will be bound to it, and you won't be able to dispute that because of the Human Rights Act that says that New Zealand will be bound. Now, the second thing that I was complaining about is the 1993 electoral law, where it is actually forbidden in all of our Commonwealth, or any country in the world, is forbidden for foreigners to be in our parliament and to be leading our courts. And there's very sound reasons for that. And they changed that. Helen Clark changed the 1993 electoral law to allow foreigners into our parliament. And currently more than 60% of the parliamentarians in New Zealand are not New Zealand born. Many of them have been in New Zealand for less than 10 years. Not only have they been in New Zealand for less than 10 years, many of them can't even speak English. They're opening up the parliaments in different languages in New Zealand that we don't even know what they're saying. And their parliamentary speeches tend to be odes and declarations to their countries of origin, that they will fight for their countries of origin. So this is what our original court case was. Now, we got hit with several $1,000s in court fees, and the whole case has transformed into being a case where we're saying that under the 1688 Will and Mary, it is the right of the subjects to petition the king, and all commitments for doing so are illegal and void. Where I'm wondering why the human rights and the immigrants to New Zealand and the Human Rights Commission are allowed to put through dozens upon dozens upon dozens of court cases into our New Zealand courts, our Australian courts, our UK courts, all of our courts, they're allowed to put them in. There are several sections for them to put in cases, and yet we, using our indubitable right of the 1688, which is promised by the king, that we could ask for declarations of right, we are being prevented by exorbitant fees that we are never going to be able to cover. So they're always going to be able to block us on the fees. I petitioned to the appeals court. They hit me with the fees. I petitioned the fees. The ruling for that is now in. I'm not going to be talking about it now, but I'm coming back here at 8 o'clock. At 8 o'clock, there's going to be a Zoom meeting, and we're going to be, I've put the Zoom meeting into the subscription below, and you're welcome to come. It's 8 o'clock New Zealand time. I don't know about English time, but we're hoping to get people from the UK, Scotland, Ireland, Australia, and New Zealand to come in and start talking about this situation that we're in, because our 1688 Will and Mary holds significant protections for our people, and in these times of turmoil and Lexis Nexus takeovers, we need all the protections that we can get. Now, this is a serious situation. But since I will just say to you the application to have our fee waiver, to have a fee waiver of the court fees, the first court fee was $1,000, was declined. And so we now have permission to go to the Supreme Court. So we're going to be having discussions at 8 o'clock New Zealand time tonight about what they have said, why we were declined on the fee waiver decline. So that's in the appeal. And so now we will be looking at that, and we're going right to the Supreme Court, which is where you want to be. If we lose in the Supreme Court, we will possibly be able to petition all the way to Westminster. So this is the next step. Now, this is only $1,000 fee waiver, but we could just pay the $1,000, but then they hit us with a $7,000 security fee, and then they've hit us with a $2,400 scheduling fee. And then there's also the loss in the first court. So all told, just to take my case to court, to exercise my petition of right that has been promised to me for hundreds of years, is going to cost me $14,000. Now, the issue here is that even if we win this case, all the common law people are never going to be able to afford $14,000 or $20,000 to take their petition of right to the court. And so that is not irrelevant. It's irrelevant whether I can pay the $14,000 or I can't pay the $14,000. What I want to do is to open up the Queen's Courts or the King's Courts, as they always should be open to us, for a declaration of right. And so what we've got to do is make this right available to all people who wish to use it. And so most people won't have the $14,000 or the $20,000 necessary to file for one petition of right. So that's what we're going to be fighting, and it's going to go to the Supreme Court. And so come back here at 8 o'clock, everybody. This is just a short video. Come back here at 8 o'clock. You can join in the Zoom meeting, or you can just watch it. But it's 8 o'clock New Zealand time. So it's 1, 2, 3, 4, 5, 6. It's 6 o'clock now. 2 hours from now, come back and we're going to be having discussions about that. So it's Kate Floss from the Ministry of Protestant Court signing out for now, and see you back here at 8 o'clock, everyone. Okay, see you later.